international commercial arbitration, and you have your have it on mute.
Yeah.
I'm a partner of Extraji LLP, which is an international boutique law firm here in Washington, D.C., doing both international investment arbitration and international commercial arbitration, as well as public international law. We also are in Bogota, Colombia. And 4 years ago, we co-founded with Ian Laird, the Washington Arbitration Week. And the first year we had about 1,500 people. And I believe that we're already in a 1,000 people number in the first 2 days. And we had a great event yesterday, and we're very happy to be connecting not only international arbitration matters, but also matters with international litigation. And this is what this panel is really about. The name of our panel today is update on the status on Section 1782 of Title 28 of the United States Code, Section 1782, which allows an international interested party to foreign proceeding to seek U.S.-style discovery from a person or entity located in the United States, and some ramifications for international arbitration. There has been much going on concerning Section 1782 lately, including a decision by the U.S. Supreme Court. But before I do that, I would like to introduce our panelists. I'm going to, together with Evan Glassman, who is here at my right, we will do so the co-function of moderators, given that our initial moderator was not able to join us for reasons completely not related to his will. So I'd like to excuse him. Unfortunately, he wasn't able to be with us. Now, let me introduce our panelists. To my left is Danielle Willis, who focuses his practice on cross-border litigation investigations on arbitration, including white-collar representations, international investigations, complex commercial disputes, international law matters, and international arbitrations. His representations have included matters involving more than 24 jurisdictions, spanning Latin America, Europe, Asia, the Middle East, and Africa. To his left is Michael Rodriguez Martinez. He is an associate at Allen & Overy International Arbitration Group. Michael's practice focuses on three main pillars: international disputes, international mining, and data privacy. Michael's experience includes investment arbitration at ICSID and the PCA, and commercial arbitrations at the ICC. His cases have encompassed mining, transportation, and many other sectors. And to his left is John Marino. He's a partner resident in the firm's Washington, D.C. office, where he practices in the international dispute resolution and litigation groups. John represents clients across a variety of jurisdictions in commercial and investment arbitration and complex civil litigation. The industries within which he has worked span the globe and include commodities, defense, financial services, hospitality, manufacturing, media, mining, and technology. And last but not least, Evan Glassman. He is deputy chair of Stepton's Commercial Litigation Group. And for more than 2 decades, he has been skillfully navigating clients through New York courts in matters involving high contentious and sensitive civil and criminal litigation issues. His diverse practice includes representations of plaintiffs and defendants in all manners of commercial litigation, white-collar criminal matters, professional liability matters, and intellectual property disputes. Evan's practice frequently encompasses multi-jurisdictional and cross-border disputes and efforts to obtain and enforce judgments on arbitral awards globally. One of the reasons why we're here is because, one, the Supreme Court's decision, and the other is whether there are any tools for arbitration practitioners to use from U.S. courts, for instance, for discovery or similar exercises. So with that, I would like to welcome everyone, and also welcome Evan's overview of the Section 1782. Thank you.
I think John is going to start
Okay.
over here with the
Sure.
overview. Okay.
Good morning, everyone. Thank you for coming to our session on 1782. So 1782 is a federal statute that allows a litigant or a potential litigant in a foreign legal proceeding to apply to a U.S. federal court for an order compelling another person, corporation, to provide evidence for use in a foreign proceeding. I'll start by giving you the relevant portion of the statute itself, and I think most of the next hour will be discussing some of the terminology in the statute and what the recent Supreme Court holding means for litigants. The district court of the district in which the person resides or is found may order him to give his testimony or statement, or to produce a document or other thing for use in a proceeding in a foreign or international tribunal, including criminal investigations conducted before formal accusation. The order may be made pursuant to a letter rogatory issued or a request made by a foreign or international tribunal, or upon the application of any interested person, and may direct the testimony or statement be given, or document or other thing produced before a person appointed by the court. A person may not be compelled to give his testimony or statement or produce a document or other thing in violation of any legally applicable privilege. So the formal requirements for a 1782 request are fairly basic. It must come from a party or interested person in a foreign proceeding. The proceeding must be before a foreign or international tribunal, and there'll be a lot of discussion on that in light of ZF and its progeny. The person from whom the evidence is sought must reside or be found in the district of the court where the application is filed. Those are the only formal requirements. At that point, a court has discretion, once those requirements are met, whether the court will decide to order that discovery be taken. There are 4 factors. They come from a case referred to as intel that are applied by the court in determining whether discovery will be ordered. I'll quickly go through them right now, and then we can get on to talk about why we're all here, ZF and progeny. The 4 discretionary factors: whether the documents or testimony sought are within the non-US tribunal's jurisdictional reach and thus accessible absent the assistance of 1782. So in essence, the court is going to consider, do you need 1782 to get at this information, or can you get at it another way? The next factor, the nature of the non-US tribunal, the character of the proceedings abroad, and the receptivity of the foreign government or court or agency abroad to US federal court assistance. It's a nod to comity. Does the foreign tribunal want this information to be procured? Whether the 1782 request conceals an attempt to circumvent foreign proof-gathering restrictions or other policies of a foreign country or the United States government. So are you applying through 1782 to get around a prohibition on this evidence in the jurisdiction in which the underlying matter, the foreign tribunal, is proceeding? And the last factor to consider, whether the request contains unduly intrusive or burdensome demands. Obviously, that's in the eye of the beholder. What is unduly burdensome to one court in a U.S. jurisdiction may mean something in a different court in a U.S. jurisdiction, and certainly means something different in a jurisdiction outside of the U.S. The court uses its discretion ultimately to decide, are they going to order discovery to be taken or not? None of those factors are dispositive, but all of those go into the magic that is the court's decision about whether they're going to order discovery or not.
I would add two things. One is that the proceeding doesn't have to be presently occurring. It could be anticipated. So courts have litigated that quite a bit. And I've had cases where we've filed 1782s and there was no current proceeding. And in one recent case, we didn't file the actual underlying proceeding for several months. So what the Second Circuit has held is that, you know, you have to show that it's reasonably anticipated. Usually you have to, typically you'll have affidavits from the interested party saying what your legal theories are, what the potential claims are. So you have to have some reasonable articulation of what you're going to do. That's one point. And then in terms of I would also add in terms of the sort of overbroad thing, I would look at this, and we always look at this as a, like any Rule 45 subpoena, because ultimately you're getting the district court to let you issue subpoenas to the parties. So, you think about strategically the scope of what you're doing. It's not helpful to give some crazy overbroad scope in a subpoena. You want to be thoughtful about it and strategic.
Makes a lot of sense.
Are we pivoting to?
Yeah, let's pivot to Michael and your thoughts.
All right. Hi, everyone. I'm Mike Rodriguez. I'm an associate in Allen & Overy. I'm actually a lead associate on Luxor at the Supreme Court. So I've lived this case for a long time, very personally. So because of that, I think I was tasked with giving a summary of what the case is about and what the Supreme Court said, and obviously will contribute afterwards my thoughts on going forward after Luxor. So Luxor was a consolidated appeal, 2 cases involving the applicability of 1782. The first one was a commercial arbitration, and the second one was an investor state arbitration. The commercial case was actually a proceeding that hadn't been initiated yet by our client, Luxor, in Germany. It was a business transaction that had been, that ZF alleged was, that Luxor alleged was tainted with fraud. They allege that ZF had hidden some information after the completion of the transaction that caused Luxor to overpay for some business units. And that sales contract included a commercial arbitration clause for arbitration in Germany. Before initiating the arbitration, Luxor sought discovery. We represented them all the way from the trial court all the way up to the Supreme Court, sought discovery in the United States against ZF and 2 of its officers on 1782. The district court granted the request, and then ZF appealed to the 6th Circuit for a stay. The 6th Circuit issued a stay of the district court's order granting 1782 discovery. But before the 6th Circuit could rule on the merits of the appeal, they filed for a writ of certiorari. The investor state case was based on an alleged expropriation of a Russian-owned bank by Lithuania. And during the nationalization process, Lithuania appointed a company called Alex Partners and its CEO as a temporary administrator. And a Russian investor assigned its rights in the case to a fund. The fund initially, during the arbitration, sought discovery in the US against that temporary administrator, Alex Partners, and its CEO. The district court granted the request. Alex Partners appealed to the 2nd Circuit, which affirmed the district court's order. There had been a circuit split on whether an international arbitration tribunal, mostly commercial tribunals, constituted foreign tribunals or international tribunals or not. So the Supreme Court took up the case. Essentially, the Supreme Court decision has 3 parts, essentially. First, an analysis of 1782, and second, an application to the commercial, for purposes of commercial arbitration and purposes for investor state arbitration. So the most important part, I think, of the court's decision is that it held that the phrase foreign or international tribunal is limited to an adjudicative body that exercises governmental authority. A foreign tribunal is a tribunal imbued with governmental authority by one nation, and an international tribunal is a tribunal imbued by governmental authority by multiple nations. So for purposes of 1782, a foreign or international tribunal has to have government authority, has to have been imbued by government authority. Court held that a commercial tribunal was not imbued with government authority. It was a private dispute resolution body agreed to by private parties in a private contract, which operates under private arbitration institutions, whose arbitrators, at least two of them, are selected by the parties. No government is involved in creating the tribunal or prescribing its procedures. The court also found that the ad hoc investor state tribunal in the case was not imbued with governmental authority, even though it was in part created, or it was in part, its power was in part established by a treaty. The court said the pivotal issue was the substance of the state's agreement. Did these two nations intend to confer governmental authority on the ad hoc panel formed pursuant to the treaty? The court found that it did not do so. In that ad hoc case, the court found that the fact that the treaty had a dispute resolution provision that allowed the investor to choose between domestic courts and investment arbitration meant that the countries had established one method of resolving the dispute that involved a government appointed tribunal with government authority, which were the domestic courts, and another one which didn't. Additionally, the court found that the treaty did not create the tribunal. The tribunal functions independently. It is not affiliated with either state. The arbitrators are chosen by the parties. There is a lack of official affiliation with states or any governmental or intergovernmental entity. The tribunal does not receive any government funding. The proceedings are confidential, and the awards are made public only through the disputing parties' consents. Importantly, the court said that while sovereigns might imbue an ad hoc arbitration tribunal with government authority, it noted that governmental and intergovernmental bodies may take many forms, but it did not attempt to prescribe how they should be structured. So the relevant question is whether the nations intended to imbue an ad hoc panel with the exercise of government authority. And in those two cases, the court said that that had not been the case. Obviously, the biggest issue with the Supreme Court opinion is that the Supreme Court did not say what government authority is or how a government imbues a non-domestic court with governmental authority or administrative tribunal with governmental authority, which has led to all the preceding following cases and us being here today.
One question, Michael. Was this an investor arbitration? Was it uncitral or was it exit?
It was uncitral. It was not exit. It was an ad hoc panel that was not under any institution.
So let me ask one question and sort of move the ground a little bit. Let's look into Article 54 of the Exit Convention. Paragraph 2 reads as follows: a party seeking recognition of enforcement in the territories of a contracting state shall furnish a competent court or other authority which such state shall have designated for the purpose of a copy of award certified to the Secretary General. And before that, paragraph 1 provides each contracting party shall recognize an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of a court in that state. So, arbitration practitioners know very well this article. That's sort of the jewel of the crown of the Exit Convention, and it does basically provides that states shall recognize an Exit Convention award as if it were a judicial decision of the highest court of the land. So, and this is somehow speculative, but your thoughts on the Supreme Court perspective, if this were still an international arbitration award, but now from an ICSID panel, ICSID convention panel. Any thoughts on that?
I think we should,
Yes.
we'll all probably have thoughts. My sense is that, and I know I don't know if we want to talk about WeBuild before we get into it.
John Slade's talking about that, yeah.
Sure, we could talk about WeBuild briefly and then get to direct questions. So WeBuild is a case currently going on in the Second Circuit. It was argued just last week, actually, before the Second Circuit. So I'll give you a quick background so that you all are familiar. WeBuild, an Italian company who was had a foreign investment in Panama, developing the lock system of the canal. There was some ongoing difficulties between the Italian company and the Panamanian government. And so the Italian company brought an ICSID matter against Panama for violating the Panamanian-Italian BIT. As part of that case, the Italian company brought a 1782 action in New York, asking for an advisor of the Panamanian government to produce testimony. And the district court, in light of ZF, denied the request ultimately. I can go into a bit more detail about the grounds on which the district court denied it. So we see what the Judge Kaplan's thinking was when the application was denied. The factors are as follows. First, the Southern District of New York assessed whether the ICSID tribunal was a pre-existing body or one formed for the purpose of adjudicating investor-state disputes. It found that ICSID does not have a standing existing arbitration panel. And in fact, this panel was the result of an agreement between the parties. The second factor the court considered was whether the BIT itself created the ICSID tribunal. Again, it found that it did not. Third, the court inquired whether the ICSID tribunal functions independently of and is not affiliated with either of the relevant BIT nations. It found that the ICSID arbitrators lacked any official affiliation with either the government of Italy or the government of Panama, or any other governmental or intergovernmental entity. Fourth, the court observed that the tribunal does not receive any government funding. It runs through the funding of each party, and so that also led the court to the conclusion that this was not a government or intergovernmental tribunal as contemplated by 1782. Next, the court analyzed whether the proceedings were public or confidential. There was some disagreement there about whether, of course, portions of the ICSID proceedings are confidential, but there are now also public component to those. But ultimately, the court found that their confidential nature counseled in favor of finding it not a governmental tribunal. Finally, the court found that since the tribunal was only one of several options available under the BIT, the party could have chosen to pursue a governmental tribunal. Instead, it chose the ICSID tribunal, and the district court, through Judge Kaplan, found that instructive. The case is on appeal right now, so it's really unclear how the Second Circuit is going to ultimately hold. The party looking to enforce the application was trying to tether the proceeding to the uniqueness of ICSID and sort of the hybrid nature of ICSID as contrasted with an unsocial arbitration, for example, and was looking for indicia within the ICSID process that made it more like a governmental tribunal or a governmental adjudicative body. Ultimately, whether the Second Circuit's going to find that that is persuasive or not is anyone's guess. The counsel for the applicant was stressing the nature of ICSID and the finality of its decision, The only way that that can be challenged is through an annulment process that is in place within ICSID, to contrast it with other ad hoc arbitrations. Whether the Second Circuit buys those arguments is unclear at the moment, but I'd be curious to hear what other panelists think about the WeBuild, likelihood of success, or do we think it's going to go more along the lines of where things have come since ZF?
Evan?
I listened to the argument. I think the applicant links it to their case to the provision you just read earlier. The panel was, I think some of the press reported they were not providing any clues to what they were thinking. So it's hard to say, but it's a lot, I think that the applicant made an argument that the ICSID procedures are different than the others. So we'll see what happens there.
Michael and also Evan, educate us a little bit on the BIT that was applicable in this last ICSID convention case, because I believe that might play an important factor. If it's an old legacy BIT, like old European model, then transparency tends to be at the lower scale. If it's an investment chapter of a free trade agreement, then the level of transparency is much higher. So, and that might play a role within the appellate court proceedings.
Yeah, well, so I'm not quite sure what the treaty provisions in the WeBuild case provided for, but it is true that, for instance, if we focus on Panama, the Canada-Panama Free Trade Agreement or the U.S. Panama Free Trade Agreement are on the side of transparency versus older bids that do not have any sort of transparency provisions, and because traditionally arbitrations have been held confidentially, arbitrations historically held under these older treaties are more confidential than otherwise. My personal view is that ICSID tribunals are going to fall the same way that all other tribunals have fallen. If you look at the pleadings in WeBuild, if you look at the Supreme Court's decision and the analysis that I laid out that it, provided for in terms of the ad hoc tribunal, all of that pretty much applies to ICSID tribunals as well. If you look at the pleadings that WeBuild filed at the district court, on all of those points, it was focusing on the ICSID as an institution, ICSID, the administrative regime, how it functions, but not on the actual ad hoc. I know we don't call it ad hoc institutional, but for purposes of the Supreme Court decision, it is as ad hoc, the tribunal itself, as any UNCITRAL non-institutional arbitration. And the statute doesn't talk about a foreign or international institution. It talks about a foreign or international tribunal. And all of the facets that you can distinguish, in my view, an ICSID from an ad hoc tribunal that relate to the factors that the Supreme Court considered are actually about ICSID, the institution, not tribunals. And that's exactly why when you read the district court opinion, it basically explains how the ICSID tribunal itself, the ICSID panel itself, is pretty much non-distinguishable from what we call an ad hoc tribunal. So I think ICSID is going to fall in the same way that the other tribunals have fallen. In my view, and again, I've already said that the Supreme Court just said essentially said it's too hard to figure out what it means to imbue governmental authority, so we won't get into it. The only thing in terms of international arbitration that I can see that somehow might have some sort of arbitration panel is, or some sort of governmental authority, is the European Union's Multilateral Investment Court. Okay. It would be a standing court, which is different from an ad hoc tribunal. It's judges that are permanent. It's funded by member states. The judges are from the countries that will be agree to go and be part of this multilateral investment court. You would think it would have transparent proceedings, and the judges' salaries and the tribunal and the institution will be funded by the member states. All of those things, it's not created by agreement of private parties. I mean, all of these things are the exact things that the Supreme Court said were lacking in ad hoc panels. But that's a ways away.
I mean, more on the sort of editorial side. It's very interesting that the court found that there's no consent by the state parties, to the extent that consenting itself in an investment arbitration tribunal is provided. It is a fiction. On the one side, the offer of the state precisely in an investment treaty or by BIT or what have you, and the acceptance of that offer in the request for arbitration. So in a way, it would be interesting to see how the court didn't see that. On the funding side, it's also interesting because tribunals are partly funded by the whole state. So isn't that recognition of that? But of course, I mean, this is a little bit of Monday morning quarterbacking, which of course we still have around before the appellate court. But anyway, in any event, Evan, pitfalls and views.
Well, I think before we get to that, so just briefly, it's probably helpful if people don't know much about 1782 to understand what the scope is of what you can get. I mean, it's really pretty unlimited. You could use it for criminal and civil proceedings. We've used it most frequently for financial records, particularly up in New York, which is the financial capital. We've used it effectively to trace assets for fraud. So, where we had a case several years ago with a huge fraud that happened in London, and we did a series of 9 different applications to trace dollar transactions around the world. So through correspondent banks in New York, and ended up helping to trace like $150 million worth of diverted funds. And so that was incredibly useful. We had, so what happens in situations like that, it's sort of tricky because, say the funds went through a bank, you find out where they first went, say they went through a bank from London to Tbilisi, Georgia. And, you have to figure out this is because these are dollar transactions. That's why New York is useful. So you have to figure out what correspondent banks in New York handled the dollar transactions for this. And sometimes it's not clear because a lot of foreign banks will have multiple corresponding banking relationships that will handle these SWIFT transactions. And so in terms of the pitfall point, one of the first things I would say is you need to be, do your research and be very, careful about what, try to get as much as you can about the which entities you're looking for, because you could spend a lot of money trying to put together an application and go after the wrong party. And it happens. And, so you have to think about that. And, that's sort of one, obviously be really careful with that. And then sort of tied to that, when you're tracing money through fraud, sometimes, you got to think about your greater judgment enforcement strategy. Because if you're issuing subpoenas, do you want to go ex parte when you're making the application, because you're worried about dissipation of funds. You really have to have all of your ducks in a row before you file anything and be ready to, say it's a transaction in the UK or the underlying cases in the UK. You want to, are you going to notify the ultimately interested party that you're making the application so they have a chance to weigh in? Because sometimes, the court will ask, why are you, you have to put in your application, are you letting everyone know you're doing this? Or alternatively, the bank that you're getting the subpoena to will notify the, account holders. So you have to be ready if necessary. First, if you want to go ex parte, you'll have to get affidavits to explain why you're doing that, and then you need to be prepared to take action. In the UK, you may want to do some kind of freezing order to make sure that as soon as you identify that you're onto them, that whoever the fraudster is, you want to be able to make sure you have freezes in place or whatever you need to do to protect yourself, because by doing you can end up just helping them get the money further dissipated. So that's one thing. Another thing I would just sort of flag, that's sort of a common thing with sort of on the other end, sort of the in the defensive part of this. So lots of times you'll see if you have you say a European financial institution involved in the foreign proceeding, applicants will go after sort of U.S. affiliates typically to try to get in the back door. So they'll go after the U.S. entity, which most of the time will have absolutely nothing to do with the foreign entity, the European-based entity, and but that's not always true. So that's sort of that's a lot of banks they are very careful, but others are not as careful in terms of separating their corporate structures and accounts and so forth. So it's if you have a situation where the applicant's going after the U.S. entity, and there's really no relationship to the foreign entity, and there's no basis to think there is, sort of common accounts, common email and so forth, you'll have to provide affidavits and evidence to say that the applicant's making an impermissible end run. But there are times that we've seen where say a UK bank and the US New York affiliate will have sort of common records, common servers, and just because say the UK bank is involved in the litigation there, and the applicant or the interested party can get the information through the proceeding, the foreign proceeding, they still can get it through. Courts have held in Second Circuit that you still could go after the New York entity, for example, if the entity has it. You don't have to exhaust all your remedies first before coming to New York. There was a case, Top Matrix was the case, a case recently where the court allowed discovery of a New York affiliate of a UK or Swiss bank in that case, even though it was sort of an end run, but the New York entity had the document, so they allowed it to proceed. So you got to really think that through, another thing sort of similar to consider is some New York the courts, there's sort of mixed language in various circuits about even if documents are not located in the district, so the entity might be in the district, but they may have access on servers or otherwise to documents in other jurisdictions around the world. There are cases where the courts have allowed discovery extraterritorially. So you have to be really careful about that. And that's something, I would advise banking clients to really have strict controls on access to documents and so forth between entities. So those are a few sort of things I would sort of say in terms of other, I've seen other things where, an applicant will go after an entity that may have been in the district at some point, but no longer is. We had a case where we were representing a Swiss bank that had very briefly had an office in Florida, but had it for years, but the applicant, use that to try to get, file an application Southern District of Florida, based on some former relationship in Florida. And, we got rid of that pretty easily. But so, if you're going to spend the money making an application, you need to be really careful, do your research, and, don't waste, your resources unless you're, confident in the facts. And obviously, if you're on the receiving end, it's easy to spot these sort of flaws. So those are just some initial thoughts.
Thank you, Evan. And now, you started looking into discovery options, but now the question in light of the Supreme Court decisions, and possibly another one, who knows if it will get up there or if it will stop at the appellate court, perhaps so. What other options are there? I mean, what are arbitrators and parties in international tribunals, especially in investor state arbitration tribunals, left with in U.S. courts?
Yeah. So look, the Supreme Court decision, for those of us who practice 1782 law, was very sad because I think it closed a very aggressive litigation strategy. It's unfortunate, but where that leaves us, I think, depends on whether you're dealing with a commercial arbitration or an investment state arbitration. So I'll start first with investor state. I think with investor state, it's really become practically impossible at this point to obtain 1782 discovery, just because of the language of the Supreme Court decision. I don't see it happening really. And just kind of taking a broader look at how that decision came up. The last time the Supreme Court took up a 1782 case was in 2004, when it took up Intel, which is the case that lays out the discretionary factors. And that was a Ginsburg case. And Justice Ginsburg loved to take cases about cross-border issues and cross-border jurisdiction. And she was the one taking up cases regarding, for example, personal jurisdiction and purposeful availment, and when can you hail into a U.S. court a foreign party. She was the one that was ticked with those issues. Obviously, she's no longer there. So what chances are there really for a 1782 case to come back up to the Supreme Court and for the Supreme Court to revisit its analysis regarding the nature of international arbitration tribunals? I don't think that's going to happen, right? Number two, I don't think any circuit is going to go against the Supreme Court by trying to create some cute difference between an ad hoc panel or an exit panel and the CF case. I just don't see that happening either. I think the only way in which someone will be able to get 1782 discovery in the context of an investor state arbitration is if the treaties are drafted differently, with some sort of language that makes it clear that the states are creating a government tribunal, or that they are providing their governmental authority to an international investment arbitration tribunal. Anything short of that changes in the way international treaties are drafted. I don't see that happening again. Now, in commercial arbitration, I think it's a bit of a different story, because I think it is going to be very dependent on the nature of the country where the arbitration is seated and the nature of the arbitration panel in that commercial arbitration. By that, I mean, as you know, many countries in Asia, in Western Europe, in South America, treat arbitrators to a large extent like judges. So arbitration rules in certain countries, and I can cite Mexico, I can cite Colombia, I can cite Spain, will say that arbitrators have the ability to act as judges, and that awards that are issued by arbitrators have the binding effect of a court order, of a court judgment. And so to the extent that the local legislations of the countries where arbitrations are seated treat arbitrators and arbitration tribunals as judges, I think that changes the landscape, and that could continue creating 1782 discovery opportunities for international commercial arbitrations. Now, if the arbitration is seated in a country that treats arbitration as a purely private institution and as a pure figure of contract, yeah, I think that's going to be impossible. But there's a lot to do there still. Now, assuming for a second that neither opportunity is going to be available in the future for 1782, either for investment arbitration or for commercial arbitration, then what can we do? And so we're starting to see this come up in our cases, and what strategies are we trying to use? So in commercial arbitration, what we're trying to do is to try to see if we can get basically either the arbitration tribunal or the foreign court of the country where the arbitration tribunal is seated to, quote unquote, sponsor the discovery. So by that, we mean having either the arbitration panel issue an order that they would like United States court assistance to obtain certain discovery that is located in the United States or in the possession of or control of a U.S. party, where the arbitration tribunal says to the U.S. judge that they are indeed acting as judges under whatever local law of that country where the arbitration tribunal is seated. The other option is to go to a court where the arbitration is seated, and many countries permit this opportunity, to go to courts outside of the arbitration panel to compel the production of evidence when it is a third party that you're seeking evidence from and not one of the parties of the arbitration. So if you can get a court or a local court order saying that it requires international court assistance and U.S. court assistance for a specific piece of evidence, then you can take that foreign court order to the United States. So it's basically trying to get either the foreign arbitration tribunal in a commercial arbitration or a court where the arbitration tribunal is seated to sponsor your 1782 discovery petition. So that's one way. The second way, and this applies both for commercial arbitrations and investor state arbitrations, is to try to come up with a viable and credible and obviously legitimate prospective litigation that you can argue to a U.S. court that you don't really need the 1782 discovery for either the commercial arbitration or the investor state arbitration, but that you really need it for a prospective litigation in a pure and traditional foreign court that may very well be connected to the arbitration, but that's the reason why you need it. Now, the risk of doing that and the pitfall is obvious. A skilled adversary will naturally ask the court enter a protective order that prevents you from using that evidence in any context other than in the prospective litigation for which you are seeking it. So you might not be able to introduce it anyway in the arbitration, but at least it may be an avenue for you to try to get some information that you would otherwise not be able to get. So that's kind of the idea that we're thinking about now in light of the Supreme Court decision.
Okay, well, I think, thank you, Danielle. And I would like to welcome everyone's remarks as to what's next. I mean, what's next given the Supreme Court decisions and what options are next, sort of in the light of the way that Dan walked us.
Yeah. So I think, again, I think that all 1782 discovery for all international arbitration is basically dead, except for the idea that you can go to the court at the seat of your jurisdiction or some other international court and have them sponsor in some way. That I can understand that. But direct 1782 applications from any type of proceeding, international arbitration, I think it's dead. I mean, in Luxor, we spent a long time arguing before the court in our pleadings and in our argument, explaining how in Germany, the arbitrators have immunity just like judges, how the rulings are final based on German law. We cited the German Arbitration Act left and right. We explained how arbitration, all arbitration, lex arbitri statutes in all developed jurisdictions have some sort of provision that says arbitration awards are final and binding and will be treated like judgments of law. And so I think whether it's commercial arbitration or investment arbitration, it's, you're dead for direct 1782. Any solution is a long-term or medium-term, project. It's either changing the way treaties are drafted to give some hook to U.S. courts to argue, to be able to find that these tribunals are imbued with government authority. It's changing, U.S. either the FAA or, let's remember that the United States is a federation, and many states have their own arbitration statutes, including Georgia and Florida that are based on the unilateral model law. And in Volt, the Supreme Court said that you can decide to apply the state arbitration statutes other than, instead of the FAA as your lex arbitri, if your arbitration is seated here. So you may want to see an arbitration here if a specific statute like California's arbitration statutes allows courts in that jurisdiction to issue subpoenas.
I'm sorry to jump in and interrupt, ladies and gentlemen. I was just notified by the building there's going to be a fire alarm test at the top of the hour in just a couple of minutes. We do not have to evacuate, so please just let the sound pass, and I apologize for the interruption here. We just learned about that now.
Thank you. Thank you.
So it's things like that. I mentioned the multilateral investment court. It's all medium and long term. But before everyone, because us in the arbitration community were very frustrated by the decision, there was a time before people were using 1782 in international arbitrations, and international arbitration worked. So, the fact that we don't have access to broad or U.S. discovery tools did not destroy the international arbitration system in the 70s, 80s, or 90s. And some people would argue it's going back to the basic principles of arbitration, actually.
Thank you, Michael. I would like, to double down on some of the ideas that Dan put on the floor. The sponsoring by court. I strongly believe that as you explained, that any treaty amendment or renewal would be one of a long term and most likely not effective to the extent that there's no multilateral investment treaty. So one new treaty really does very little in front of 3,000 treaties that are now in force. Plus the European championed multilateral investment court has flaws of its own that no need to go there really, and it's a regional project at best. So what practical solutions would you offer clients when you are confronted with the lack of Section 1782 in the short term? That's sort of the big question.
Well, one option is certainly to look at state statutes. So in the United States, most prominently New York has a local statute, which is 3102, which allows you to get discovery in aid of arbitration. So it's certainly a possibility that you can try to use here. For it doesn't limit it to commercial arbitration or to investor-state arbitration. Obviously, the limitations as compared to 1782 are obvious. Number one, you could only target a New York-based party or documents located in New York. Number two, it's not commonly used in the context of international disputes. 3102 is most commonly used by insurance companies in insurance arbitrations who want to preserve evidence that they fear is going to be destroyed prior to the commencement of an insurance arbitration. So you're going to get judges in New York that are maybe not familiar with it. But look, it has been done, and it could certainly be done in the future for New York-based parties. So that's one alternative. There are other statutes in other jurisdictions, Georgia, Florida, Texas, that also allow you to do suit discovery, but mainly for the purposes of preserving evidence that you fear is going to be destroyed. So I think there's an argument to be made, at least in circumstances of emergency, that you could try to use those types of state procedures to get some evidence in anticipation of or during the course of an arbitration to preserve evidence. But those statutes, as far as I know, have never been used in the context of an international arbitration. So really just looking at state laws, and most prominently 3102 in New York.
Thank you, Dan. John, I see you nodding, so
No, I agree. I mean, it's an uphill battle. We're not sure, and so maybe some parties hold out hope about WeBuild. But I agree, looking at local state law is probably the most obvious next alternative. It's imperfect. Perhaps it grows in importance over the next few years in light of ZF and its progeny, but you're going to be trying to fit square pegs in round holes, and you're going to have to be as creative as you can be.
well, good. Now, we have one question from the online audience, which is, what about international litigation? What about litigation that comes to court in the U.S.? Are those at risk, or really nothing has changed concerning those litigations using Section 1782?
I think that there's no limitation on that. ZF doesn't touch that. So I think it's, that's, moving ahead strongly.
Okay, excellent. So I would like to open the floor for anybody who might have questions, and please, identify yourself, and I'm not entirely, let's I don't see any microphone, so if it doesn't work, come up front and speak to us. Yeah.
I'm so I'm working in Paris as a California. It's very interesting what you're saying. Michael, what you were saying about, saying about the arguments that you put up when you fight it before. I was reflecting on my own experience in France about how courts are structured and how they're financed. Because I think one of the big arguments, the big rationale about it needs to be imbued with government authority needs to be that sometimes it needs to be taxpayers' money paying the judges. And I find that extremely interesting because if you look at France, for example, all of the commercial litigation goes before the commercial courts. The commercial court is financed by the parties. But it doesn't get more governmental in a way. It's in the civil procedure code. But you come up, you pay a small fee, you go to Switzerland, you pay a bigger fee to go to the courts. So you're still paying up. It's the parties, the litigants themselves that are paying up the dispute mechanism. Even though it's not an arbitration per se, the fact of the matter is that the financial situation of that institution, that adjudication body, is financed by private actors, very similar to the arbitration. In fact, these judges aren't actually even paid in France. They're educated they usually hold their obviously already, so they're not even paid. So if we apply that rationale, it means that all the commercial litigation rising out of France could not benefit, perhaps, of 1782, even though it is. And so I think coming back to this, I was curious. You cited when we were doing this exercise what you've been doing about. You took the case of Germany, saying Germany they have immunity, but did you go jurisdiction by jurisdiction just to show just how overly restrictive the rationale has been in ZF? Because I think the decision for me is just absurd. I don't actually understand how it can not apply to it. I understand why you won't apply,
Right?
But I don't understand. To me, it doesn't matter.
So
Have your attention, please. May I have your attention, please? There has been a fire emergency reported in the building. May I have your attention, please? May I have your attention, please? There has been a fire emergency reported in the building. May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. The building.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. The building.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. Please leave the building by the nearest exit or exit stairway. Do not use the elevator.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. The building by the nearest exit or exit stairway.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. The building by the nearest exit or exit stairway.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. Please leave the building by the nearest exit or exit stairway. Do not use the elevator.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. Please leave the building by the nearest exit or exit stairway.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. Please leave the building by the nearest exit.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. The building.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. The building by the nearest exit or exit stairway.
May I have your attention, please? May I have your attention, please?
There has been a fire emergency reported in the building. The building by the nearest exit.
May I have your attention, please? May I have your attention, please? There has been a fire emergency.
Okay, good. So
We apologize, officer. We didn't know.
no, well, this is one of the things that, you know, fire drills need to be surprises, otherwise it doesn't work. So we're truly surprised. I just want to you know, give the floor. I saw, do you want to conclude your remarks or you're good?
I think
Yeah, I mean, so I think, so I can tell you what we did. We explained as much as possible how a tribunal in Germany, a commercial arbitration, can only function and only works because the government has given it the power to do so from the beginning to the end. We made the same point on the FAA, right? The state is the sovereign, and only through law can you give, you know, a power to a non-governmental entity to actually act in a way that is enforceable in any sort of manner. That's why you have laws that say arbitration agreements are enforceable under law, arbitration awards are enforceable under law, et cetera, et cetera. So it's just a nice slogan, but it's not true that arbitrations are just a matter of private party, and that's everywhere. We had an amicus submission that went through different countries and explained that as well. The reality of the situation, from my view, again, having been involved there, is if you look at the text of the treaty, of the statute, you can't really get to where the Supreme Court got with the textual analysis. But if you look at the legislative history, it's quite clear that the statute was talking about government tribunals. And we went back and forth for a very long time about whether we stuck with a textual analysis and how we dealt with the legislative history. We stuck with a textual analysis because it was more beneficial to us, obviously, and the Supreme Court, the majority of the Supreme Court are textualists. My view on the decision is what the court did was look at the legislative history, figure out what the actual answer is, and then publicly do a textual analysis to get to the answer that the legislative history tells you. So that to me is why they don't actually answer what it means to imbue or how you can imbue or what is governmental authority. You would think that governmental authority is this award has the power of law, right? It's binding under law and it's enforceable as a judgment. And we made that point. And every statute, every lex arbitrii will say it, and the convention will say it. And that apparently wasn't governmental authority. Right, so they talk things about how it wasn't permanent, as if that has to do, a government can have a permanent, only has permanent bodies, consent of the parties, private parties, confidentiality, as if governmental tribunals, administrative tribunals, like immigration tribunals in the United States are public and not confidential. It's just, so I think that's just, you know, they read the legislative history and that's where they got to.
Thank you, Michael. Anybody else has a question? And if not, I would really like to thank Greenberg for hosting us, surprising us in the best of ways.
You're telling us.
No. Thank you for this marvelous welcoming, and we are really grateful to be hosted here, Washington Arbitration Week. You know, John from Crowell & Mooring, and Michael, and of course Dan and Evan. Thank you very much for being on this panel. And one question not to be answered now is how do you keep on defending international arbitration, given that it seems that the challenges are coming from everywhere. Like we have the U.S. Supreme Court, we have you know, the folks in ancestral discussions, and there are more. But as Judge Brower said yesterday, we'll be ready, you know, for the next one. Let's see. Thank you very much, and the next panel will start, I believe, in 15 or so 20 minutes. Okay. Thank you. And
Yeah.
Yeah. No, bro, you don't forget.
Cada día son dos.
Sí, cada día son dos veces. Evan, thank you very much. Yeah, thank you.
We planned for the fire.
I know that, and it, good. So,
Yeah.
the news about 1782
So,
came out
it's
about,
have to amend this
I was actually thinking about using that one.
Yeah, it's have to go through
Amendment statute,
It's not possible.
the reality of it,
But,
I mean,
you
it's
know,
still really useful.
it's important.
but